Shall I introduce myself first? I'm Sailesh Mehta. I'm a barrister. I specialise in fire law. Today I am interviewing Karen Galloway. Karen is a solicitor with broad and deep experience in aspects of fire prosecutions. Karen, you work for a local authority?
I do. I work for North Yorkshire County Council, but since 2008 I have been carrying out prosecutions on behalf of the North Yorkshire Fire and Rescue Service.
And I think the way that the local fire services operate is that rather than having an in-house lawyer, they outsource their prosecutions to a solicitor in the local authority.
Yes, it's all done via a service level agreement. So basically at North Yorkshire County Council do all of the legal work for North Yorkshire Fire and Rescue Service, and a part of that of course is the enforcement side of things along with prosecutions. And I think we're on about number 27. So we've had a lot of cases in the last 15 years or so.
And firstly, it's a pleasure to meet you again. We haven't worked together for about a year, but we have been working in some fairly large cases, and I'm hoping that we can talk through some of those. And with a few questions and reminders, perhaps we can go through some of the practical problems that we had in the cases that we've done together and how we help to solve them, whether it's practical in terms of the evidence itself or in terms of the law. And I was just researching a little bit before this interview, and I think our first big case was in 2012 relating to a couple of fatalities that went back some years before then.
Yes, are we talking about Buckrose Court?
We are, yeah.
Yeah. Now then, that was a fire. Unfortunately, that was a fire that took place in 2009 in a block of flats, which resulted in two very young jockeys tragically losing their lives that night. Fire swept through these premises very, very quickly, and as soon as the officers were on site, obviously during trying to put out the fire, but also afterwards in the cold light of day, they were taking stock as to what had happened, and also investigating the start of the fire and all of the circumstances that led up to those tragic events of that evening.
And of course, it made the local papers as well as the wider media because of the tragic death of not just two people, but two well-loved local young jockeys. And their families took an active part in the investigation as well.
Absolutely. And part of our role, the fire officers that were involved, was very much about keeping the family up to date with all of the investigation, seeing it right through to the end, actually, when the responsible person, the owner of the flats, and Mr. Foster, was actually sentenced in May 2013 to a 12-month prison sentence, which actually, for fire safety offences, was unheard of. Very, very long and very, very difficult case.
And I think that's probably the longest prison sentence that you've come across in your broad experience.
It has, Sailesh. And I think, don't forget we had two fire officers that were commended by the judge in the Crown Court in Leeds in May 2013. Mr. Foster pleaded guilty to the 4 offences, and the tireless work that the investigation involved was absolutely extensive. Very, very difficult case. And Sailesh, you were great, got you in quite early. In fact, it was our first case together, and you came recommended to me by another well-known chap around fire safety. And we started off, and then you came along and you took the case and you ran with it. And effectively, we gathered all of the evidence. We had difficulties, I don't know if you remember, but Mr. Foster, if you remember, claimed that other companies that he was a party to should be the responsible person, and this would include the letting agent of the premises. So we had extensive work around that, trying to bottom out the control element of that, which of course we need to establish to make sure that the responsible person is the right person with whom we then go on to prosecute.
So one of the complicating features of this case was that a number of authorities and bodies were involved. So we had the police involved, the local authority, we had the fire services, and of course the coroner's court as well. Did that add to the difficulties you had?
Well, I mean, yes. I mean, obviously, we don't want to get in the police investigate. You know, we don't want to get in. Don't want to get in the way of any police investigation.
Well, this was an arson investigation because the fire started. It was started deliberately, and in fact, the person was arrested and charged with.
He was. Yeah, he was. He was charged with arson, and that was a separate offence to our involvement. Yeah, this was a young man who actually took umbrage because he wasn't invited to a party that evening, and he actually set fire to the rubbish underneath the stairwell, which the responsible person knew about because half of those items in the stairwell, which should have been clear, were flammable and actually belonged to the owner as well. The coroner obviously was involved. That involved. That then meant the family being more involved, and we had to negotiate our way. It was a really difficult case, so we had to manage it. We had to manage expectations. The press were involved, as I say, the coroner were involved. So we had to negotiate our way through, what really was quite a difficult case, and investigating all of the information around the companies that, we were trying to be. I think we were just being led down a path, and we even interviewed the other directors in the cases, and also used our powers under Article 27. Sailesh, I don't know if you remember, to actually do some more digging and get the right information.
We had a defendant, as often happens, who wasn't cooperating with our investigation, and so the range of powers had to be used to discover things that weren't readily available, including who really the main purpose of all of the investigation was to find out who the responsible person was.
That's right.
And I think you started with many lever arch files from the police investigation, as well as the background files to the buildings. And there were 2 buildings involved, and these are local authority files.
There was
How do you manage that volume of material, and in terms of disclosure as well?
Well, this whole case was, just took over my life from start to finish, really. And it was obviously helped by yourself, because I needed expert advice and assistance around the disclosure exercise. I don't know if you remember, but there were 26 lever arch files of disclosure that I personally had. And my officers also had to become involved in all of that disclosure exercise. And I think, Sailesh, you actually assisted us in drafting all of the schedules, and then deciding what could be disclosed to the side and what couldn't be what couldn't be disclosed. And that in itself is such a painstaking exercise, but one that's so important, because we need to follow the legislation that governs the disclosure. And also make sure that the defence has the information that he's entitled to at the end of the day.
Because of course the defendant is entitled to a fair prosecution. And
absolutely.
One of the difficulties that we had is that in 2012, the fire brigades, and particularly the smaller fire services, didn't really know what disclosure was, and certainly had no dedicated disclosure officers.
No. Well, no, they didn't. No, they didn't. And I can remember my officers, spending hours and hours and hours, sifting through papers and producing these schedules, led by yourself, Sailesh. And I know yourself. You say it's important to get the right person. It's important to get the right offences, and make sure that we actually lay down the right information. And make sure that we are prosecuting for the right articles. And I don't know if you remember, but there were actually 17 offences initially.
Yes, and it's not unusual in fire cases for there to be a plethora of breaches that are pleaded. Did you then narrow down those 17 original offences, and what was the process by which that was done?
I mean, at the start of the process, we actually listed all of the articles which had been breached, and then when we sought your advice on this issue, you were very, very clear in your advice that we need to narrow it down. That doesn't detract from the case, but what it does do is it prevents confusion, and perhaps if we have to involve a judge and a potential jury, what we don't want them to do is to get embroiled in I suppose volume. What we want to concentrate on are the serious offences which actually encompass the whole of the circumstances of the case. So I know we took some persuading. I know in particular there's a few officers who weren't they didn't like that approach. But my goodness me, it's one that we've actually gone on and used time and time again, and it attracts an early guilty plea, and it does achieve the best outcome. And of course, what you always say is we'll do this on the basis that I'm able to open fully on the case.
And I think that's got to be the bottom line, that whatever negotiations there are between the prosecution and the defence, and they always result in a reduction of the number of original charges, it's got to be on the basis that the judge, the court, has a fair idea of what the case is about, which means opening on the full facts. And so would you class yourself now as more of a minimalist when it comes to number of summons or an indictment?
I mean, obviously, since COVID came along, we haven't had that. We haven't had any cases, but no, I think no. I always defer to yourself, Sailesh, for further guidance on that. But inevitably, to begin with, I think there are always more offences that are identified. It's just how we include them in the final indictment that we lay that again you draft for us, and that is what's placed before the court, isn't it?
Karen, you mentioned that the judge commended two of our officers.
He did.
And one in particular who was instrumental in the investigation, a chap called David Watson. And in fact, he forms a common thread in a number of our prosecutions. How important is it to have an officer that is dedicated to a case and dedicated to a prosecution with support?
I think it's very important. I mean, at the start of our relationship, Sailesh, and actually when I became involved with North Yorkshire Fire Service, there was actually two officers, if you remember. There was Roy Ashman, and who's now retired, and Dave Watson. And the two of them made a great team. And when Roy retired, David took up the reins and was incredibly dogged in his method of investigation. He was very, very thorough, and very determined to make sure that the right outcome was achieved, and meticulous in his evidence of gathering, and his notebook, and basically, if I ever said, right, we need to do this, go back, can we have this, he would go and get it, using Article 27 powers. Or knocking on doors, doing all of the extra things, probably over and above what might happen in the norm. So very, very good officers, very consistent, part of a small team, very dedicated in their enforcement roles to making sure that North Yorkshire was in terms of fire safety was taken very, very seriously, and they were very, very keen to send out the right message at the end of every single case to act as a deterrent for these offences. The consequences of which were catastrophic.
Yes. And I think you liaised with the families as well of the deceased.
Yes.
And kept them abreast of what was going on. But presumably you had to be careful as to how much information you could properly give them.
Absolutely. Yes. I mean, we did have to keep in contact with the family. You can imagine their heartbreak. In particular, one of the victims, Jan. I mean, she was an only daughter for this particular family, and
of course there's always a tension. There's a tension between how much information the families want and how much you as a prosecutor are allowed to give them.
Yes. I mean, we had photographs, obviously, that would not have been very pleasant. Don't forget a very, very difficult case, because you're listening to the impact statements, of course, that were read out by the family. And personally, that statement from Mum is always going to be etched in my mind.
Yes. Was that the first case you've done where impact statements were used and placed before the sentencing judge?
Yeah. I mean, yes, it was. I mean, we had a couple of prosecutions before, but this was the this is probably the largest case that North Yorkshire have ever had to deal with, and it was tragic, and it was complex. And it was absolutely right to bring you in, Sailesh, at that point. And I think we also used Colin Todd.
I was going to get on to the use of experts, which again is a theme in all of your complex prosecutions. Just tell us a bit about the need for an expert and when you made the decision.
I didn't. Let me just stop you there. I didn't make the decision. It was recommended by you to me to make that decision, and that's exactly what I did. So on your advice, we brought in Colin Todd, who is an expert in law, the field of fire safety law, I think what we wanted to do was just to make sure that everything had been looked at. We hadn't missed anything, and obviously an expert is not there to say what's going to happen, but I think we needed his advice and his expertise as well on the counts and the seriousness of the case, and again to assess our evidence.
Yeah. And I suppose an expert with the clout that Colin Todd came with, the fact that he was one of the Grenfell experts, makes it a lot easier when you're prosecuting to get hold of someone with that level of expertise, because one just doesn't know who the defence are going to instruct as well.
No, and I've got the saying for me is you can't defend the indefensible, and one of the most important things I think for the fire authority from our perspective is to avoid a lengthy and costly trial, if at all possible. So the whole purpose of actually gathering the evidence and bringing the prosecution and laying it out and making sure that everything has been followed and all of the paths and all of the stray threads, if you like, have all been cut off, and what we're left with is a very compact set of facts, which is very, very tight, and really there's no room for manoeuvre, and once we do that, that's when we actually try and get the early guilty plea, and then we can proceed to sentence.
And so really what you're saying is massive investment of time and effort and money as well at the early stages to get the best and strongest case possible.
Oh, absolutely. And I think bringing in the right people at the right time is absolutely essential. I'm always amazed by the diligence of our fire officers. They didn't join the fire authority to become investigating officers. And so these cases, the attitude that they have and the dedication that they show is second to none.
Can I move on to another case that involved a nail parlour? And I think one of the interesting aspects of this case was that there were two responsible persons that we were saying were responsible. It really was a very dangerous situation that the officers found when they visited this nail parlour.
It was. So this was a nail parlour in the middle of York in Stonegate. So it was in the heart of York. It was a beautiful building on 4 floors. Within the building, you had on the ground floor a nail parlour, but actually you had a basement full of flammable materials, which could have gone up at any time, thereby probably taking out a building that was centuries years old and buildings to the left and right of that. And if anybody's ever been to York and walked down Stonegate, it is one of the oldest streets in York that remains standing with all of those beautiful buildings. So when officers actually had a look at the premises, they found people sleeping upstairs, and eventually it was discovered that these people were actually illegal workers, and they'd been taken on by the 2 defendants. One was the person who leased the premises, and the other one was the manageress. And again, we had a great outcome there of suspended custodial sentences plus all of our prosecution costs back, which is very important when it's a public body. And we had prohibition notices that had been ignored, and also a border force, immigration, they were involved. They actually carried out an inspection of the property or a raid of the property.
How did that work? Were they willing to share information with you and vice versa?
Yeah, absolutely. The Fire Authority will always work with other statutory agencies, public agencies, and basically they just come at it from a different point of view. So obviously UK Border Force coming at it from an immigration perspective, and you have illegal workers in unsafe buildings that are at risk of significant harm or even death, and that's when the fire service comes in. And this particular case also involved Thames Valley Police, who also wanted details of our investigation passed to them as intelligence, and that intelligence actually assisted Thames Valley Police with a number of warrants being executed at addresses in London, Reading and York. So it was very much a massive operation, massive exercise, and we shared our information with the number of agencies involved in that. There was never any issue for as far as we were concerned.
One of the difficulties in relation to at least one of the responsible persons was that it was felt by her own account that her English was almost non-existent, and it was difficult to know what relationship she had with the ownership or control of the premises.
Yeah,
I think a bit of detective work gave you a breakthrough.
There was some detective work. I mean, my fire officer, we talked about Ripper as well, and surveillance to witness the people sleeping above, and people coming and going from the premises. The lady in question was the manageress. She basically played I don't know anything. We did have an interpreter, so we got an interpreter in. And that wasn't a problem. And then we realised that the English wasn't so bad after all.
And I think that we managed to somehow find the landlady,
yes,
who was able to give a lot of information, including the lease.
Yes, that's right. So in order to establish the responsible persons, it became very quickly, we realised very quickly that the building wasn't owned by these people. The building was owned by a third party, a landlady. And actually, myself and the fire officer went out to speak to the landlady and inspect a load of documents in order to establish the element of control that we needed for the manageress to be culpable. So there were two defendants, and both pleaded guilty to 5 offences between them. Yeah.
Can I move on then to another of our cases? This involves a different sort of premises, a nightclub, and I think it's called Tokyo Nightclub.
Yeah.
And amongst the many difficulties in the prosecution of that nightclub owner was, I think, the vast number of companies that he was the director of.
That's right. So we have had a few nightclub cases, Sailesh, haven't we? But this one really was complicated, because when we started to uncover who the operating company and who the operating person was behind the nightclub, we discovered that this chap had actually 26 companies, and all of these companies some of them had folded, some had been given different names, and so the extensive searches that we carried out with Companies House to try and bottom out the 12 or 13 charges that we originally brought against both him in his personal capacity as a director using Article 32.8, and also the company. So I don't know if you remember, you drafted the indictment, and we had numerous charges around the offences, and we laid them all against either the company or the managing director in his personal capacity. And that particular case, if you remember, involved Lincoln Fire Authority, because they had issues with him down there because he also owned another nightclub in Lincoln. And this therefore turned into a combined prosecution at which you were our joint counsel, and this was the first one in the country. And this was very, very successful. And the defendant was ordered to pay in total £175,000. And really that was because of the seriousness of the offences. By not having a working fire alarm in the nightclub, there was no detection system, there was no emergency lighting, and I think he brought a generator in at one point to run the club because his mains electricity had been cut off owing to non-payment. But it certainly was difficult, wasn't it?
Right. And I think one of the many difficulties was amongst the morass of companies, one would be shut down and another one spring up from the ashes, doing exactly the same job. And so one continuing offence might actually involve 2 or 3 companies.
Yes, absolutely. So what we had to do there was very carefully work out what date did that culpability start, what date did that culpability start, and actually encompass that within our charges. So between certain periods, it wasn't just a one-off date, which I know sometimes we have laid our information on that basis. When we get involved, we usually take it from there. But if we can retrospectively apply some culpability, then obviously that's what we do. And again, we needed your help in unpicking all of that nightmare called corporate veil, which exists for a reason, doesn't it?
Yeah, absolutely. And the real difficulty was whether the defence would argue that the corporate veil can't be lifted,
Yes.
and therefore only the companies can be prosecuted.
No. Well, that's right. That's right. And actually, if you remember, I mean, there's not many cases, I don't think, where the actual the director is sued in his personal capacity, because that's why you have companies to actually take away the culpability there. So yeah.
Can I move on to another nightclub case that you were involved in? And this is possibly one of the most horrendous, most dangerous situation that one could come across in a nightclub. This was the Cuda nightclub.
Yes, yeah. This was overcrowding. Do you remember when we got to the bottom of it? I think the licence was for 600 people, young people, of course, all out enjoying themselves on an evening. When actually officers physically counted using the CCTV about 1,300 people going into the nightclub.
And this was a club that had a maximum capacity of around 600, I think.
It did. And if you remember, there were 3 defendants. So there was the company, there was the director, and then there was the security company.
And was that unusual to prosecute the security company, who ordinarily you'd assume would have no duties when it came to fire safety?
Yeah, no. Well, that's right. I mean, obviously their defence was, listen, it was nothing to do with us. We were just manning the door. We were clicking people in. We were clicking people out. And we were just being told what to do, which was basically, let more people in, keep letting the people in. And so, again, you had three defendants, and I think probably two or three defence company solicitors to deal with as well. And I think, I'm not sure if there was a police investigation.
I think that's how the whole thing started with the police, because there was a complaint from one of the nightclub visitors who was feeling very faint because there were just so many people crammed into
That's right. And of course, with that came the danger of not being able to get out if there was a fire. But don't you remember the defendants were all trying to blame each other?
Oh yes, and particularly the manager seemed to be at the centre of it, and there must have been pressure on the manager from the company to get as many bodies in who are going to be paying and drinking. But on the other hand, there was a tension with the security company who were saying they had pressure, and if they had complained, they might not have been hired, and their services might be dispensed with on a future occasion.
Yeah, but I think we took the view again on your advices. Do you know what? Let's just put everybody in the melting pot. The liability is there, and let the courts decide, and let it will out, if you will, and see what happens at the end of that. I
think eventually it was accepted by the security company representatives that the company did owe duty.
Yes.
Under the fire safety order to make sure that the bare minimum level of safety was adhered to.
it was. And obviously then you had the heavy mitigation coming in from the defence lawyers, the defence lawyers, which would bring any amount of sentencing down.
Yes, and they were probably right about that, and that there was some sympathy from the court, despite the fact that, of course, they pleaded guilty. May I move on to possibly the last case that we're going to discuss, and that's another fatality case, and that was unusual in terms of the facts as well as the law.
Yes, that was again in our area. Obviously, North Yorkshire is quite an extensive area, and this was known as Potter's Lodge, and this was a very sad case where an employee of the responsible person lived in, I think it was a converted stables. I think his children. I think the owner's children used to play pool in there, didn't they? When they were young, and keep the dogs.
There were 2 floors, weren't there?
Yeah.
It was stables originally. There was the main house, and then in the gardens area, extensive garden areas, was the stables that had been converted into use for the children. Yeah.
That's right, and it was they had a bedroom, it had a kitchen, it had a toilet, and if you remember, Sailesh, there was a Velux window. There was a Velux window, and the end and the doorway at the end, which would have been a fire escape, was actually boarded up. Do you remember? It was bricked up. Yeah.
And so this was a man who was living on the first floor, the top floor of the converted stables, and there was a fire, and he couldn't escape and died. And I think one of the first questions that needed to be answered was: is that actually a breach of the fire safety order? Because many people would say, well, if you've got someone living in your attic in your own home, you wouldn't be in breach of the order. It wouldn't apply to your home accommodation. And so we had to grapple with the law relating to that.
Well, yes, and again, I think you were the driving force behind this, because I think you persuaded the powers that be to take a chance here and actually argue the legal point that does the fire safety order not apply to this particular building, which was actually within the curtilage of a small estate. So you had the main house, then you had the outhouse or the shed or the conversion, and then obviously you had the curtilage of the property. We were already, do you remember, we had a solid legal argument. You went through various case law, you put forward that legal argument, which we would have had to have tested had the case gone any further, but because of the evidence and because of I think the defendant's legal advice, I'm guessing it was to plead guilty. And so that wasn't particularly tested, was it? Do you remember?
Absolutely. But I think one of the things you had to do is to make sure that the fire services senior personnel were aware of the potential for a trial and the potential for losing, even though you and I had advised that there was a better than even chance of success. There was a real risk of losing, and the fire service, I think, were entirely supportive of the prosecution.
Entirely. I mean, it went all the way to the top. Obviously, we had to come up with a cost, a figure, because obviously it's public money. We had a couple of meetings, didn't we, Sailesh? And they were very much on board with the legal advice that they were being given, and that ended up in giving the okay and the go ahead for actually carrying on with the case, and with the thought process is that, well, let's test this, because a man has died, and I think the fire authority felt it very important that the right result needed to be obtained. Yeah.
And of course, given that this was a fatality, one of the things I think you rightly sought was advice on not just the evidence and sufficiency of evidence, but also whether the public interest test was achieved. And here, given that there was a fatality, and that our joint view was that there was enough evidence, and the law was on our side, that it ticked both of those boxes to merit a prosecution.
It did. And if you remember, this particular case involved much contact, if you like, with the planners as well, with the planning authority, because of course we were being presented with all sorts of plans, that this is not part, that the fire order should not apply because of this and this, and then we got involved in all the building regulations and all of the planning, and so we even had documents and files and plans from the planners as well. I don't know if you remember.
Absolutely. And so fire prosecutions, particularly a case like this, are unique in that they involve so many different third parties, and vital evidence can be held by third parties.
Yes, absolutely. And I think the fire officers, you do have to have knowledge of how to go out and actually obtain the evidence and make sure that it's admissible. It's vital. The first, I would say the first few days after an incident is absolutely vital in terms of collating evidence, going to speak to people, getting witness statements, taking down notes in your notebook, and then turning them into witness statements, and literally starting from scratch and outlining the basis of your case, and then adding the meat to the bones, and also involving yourself and anyone else who we need to involve, Sailesh, to be fair, to make sure that we get the right outcome.
And it certainly, if we look at the early years of prosecution, so 2012, which is where we started, is it your experience that fire officers who attend possible scenes of crimes and venues for prosecution are well trained enough to gather evidence and to note the evidence?
I think to be fair, I think the officers have grown in confidence and knowledge in that particular area. I think when we first started out, there were probably some issues, if you like, in doing that, and maybe one or two missed opportunities. But I think that in the main, I think that the officers receive very good training. And I think that they are now much more aware of who they need to speak to, what questions they need to be asking, and how they need to be recording and documenting the evidence that they then take forward. And, not all cases lead to prosecution. I mean, it's depending on many things, the Prosecutors Code for the Crown Prosecutors Code, and also obviously the public interest. And the Fire Authority itself are very aware of the local demographics and the effect that it has on businesses as well.
Exactly. Karen, we've hardly touched the surface of the sort of cases you've done and the range of experience that you have. It's been a pleasure talking to you, and I could go on for many hours, as you know. But it's been wonderful talking to you, and thank you very much for sharing.
Sailesh, it's been my pleasure. We've had a very good working relationship for many, many years now, and long may it continue. I do know that the Fire Authority are very, very keen always to seek your advice whenever the need arises, and I would like to thank you personally for always being there and being very much a support and just a phone call away. It's very, very much appreciated. Thank you.
Well, Karen, you'll know that this is part of a series of video webinars that are being run by the FPA, and it's been a pleasure having you on, and I hope that we can invite you again in the future.